I'll call this meeting to order. Welcome to meeting number 16 of the House of Commons Standing Committee on Citizenship and Immigration, Health and Safety. Today's meeting is on Differential Outcomes in Immigration, Refugees and Citizenship Canada Decisions. So we have two panels. We are joined by Mario Bellissimo, Certified Specialist in Citizenship and Immigration Law and Refugee Protection, representing Bellissimo Law Group Professional Corporation. So if we can start with Mr. Bellissimo. Mr. Bellissimo, you will have 5 minutes, and you can please begin.
Good morning, Madam Chair, members of Parliament, and fellow panelists. Thank you for the invitation to appear. The study of differential outcomes in IRCC decisions is definitely complex and an expansive topic, and I'm happy to take questions on that generally. But for purposes of my remarks, in my opening remarks, I'm going to focus on advanced analytics as part of AI, artificial intelligence solutions. My professional career has been dedicated to the practice of study of immigration, citizenship and refugee law, immigration law for brevity. For the past near 25 years, I've accompanied applicants in the journey from application stage to the Supreme Court of Canada and back, working to advocate for the preservation of foundational legal rights like equality, fairness, and individualization in immigration law and policy. AI engages all of these issues. In fact, for some like me grappling with the enormity of the implications surrounding the expanded use of AI solutions, one can find themselves equally in awe and in dread. Simply put, the awe part is the exciting and transformative possibilities. Expedited processing, minimizing officer error bias, enhanced user access, and better information gathering, amongst other potential gains. However, part of the dread arises from concerns AI will only perpetuate existing racial, socioeconomic, and political divides and discrimination that are so entrenched in our society. AI, as we all know, is already being used to triage applications, but the potential is so much more, and the plans are far greater than triaging. The hope is that if AI is applied properly, we can avoid the missteps we've seen and witnessed domestically and internationally, where AI has reproduced bias. And like in the Supreme Court of Canada case in Ewart, or internationally, the risk classification assessment tool used for detention in the United States, or the border control lie detector used by the European Union at borders, or even the New Zealand technology to identify potential overstayers. These are just a small number of examples of AI use gone wrong. At its core, until we are all required by law to be on a relatable informational plane, applicants, the public, and many stakeholders remain at a disadvantage in understanding how parts of their lives may be reordered by AI. I remain optimistic that improvement is possible, and recommendations this committee has already heard with respect to an ombudsperson, enhanced IRC training as set out in the Polaire report are potential important steps. But even more will be required in the presence of disruptive technology to avoid potential discriminatory consequences. As set out in the 10 recommendations in our brief, efforts to transform immigration delivery must include legislative measures be put in place for transparent, explainable, and equitable AI governance, recognizing the technology is not neutral and that historical data, values, and norms propel AI. Training AI programmers, analysts, and thought leaders, as one example, must not only be reflective and responsive to vulnerable persons and groups, but must be required by law to ensure diversity and inclusion balances are maintained for those that train and drive the technology. An algorithm charter like in New Zealand, external audits with enforcement powers, and mandatory external consultations are steps that have been recognized internationally as effective and essential for proper AI governance. We cannot only look at where the use and the technology is today. Thus, the need to work with and leverage all stakeholders are acute, given the rapidly evolving challenges ahead. IRCC is staffed by many hardworking, well-intentional individuals that want to make a positive change. Our council, academic, and AI community in Canada are also well-positioned to make a meaningful contribution to IRC's use of AI. If we put in the collective work now, pressing for a strong and modern legislative framework predicated on collaboration, oversight, transparency, and responsible implementation, we have the potential to be a world leader. There is much work to do. But this is the time to reimagine, revolutionize, and reorder our Canadian immigration decision-making built on a strong legal and technological foundation grounded in legislation, a foundation undisturbed no matter the international and technological pressure that may be on the horizon. Thank you.